Good evening, good vach, Shevuos tov. Let's light up the darkness. Who's in the house on a Saturday night when the world is safer? Lucy in Minnesota, John in Maine, Yosef in Sierra Nevada, Belle in Texas, Joe in the Inland Empire, Aoife in Florida, and I'm sure a few East Coasters will find their way here, and I honor you because you're my heroes tuning in at 1:05 a.m. Wow. You're awesome. Your dedication to Torah will earn you a big zechus, a big merit, and a big sachar, a big reward in this world and in the world to come. We should say amen. But we'll get right into it. Our daf is page 46 here in Tractate Shevuos, the 26th volume of the Talmud. We're discussing Mishna number 1 in chapter 7. We're picking this up at the bottom of page 45b. Rami Bar Chama would cite this verse about Rav Sheshes, quote, "And David laid up these words in his heart," from 1 Samuel 21:13, as Rav Sheshes took it upon himself to find sources that would support or contradict the statements of Rav and Shmuel. As it is recounted that Rav Sheshes encountered Rabbi Bar Shmuel and said to him, "Does the master teach any laws, any halachas, about a hired worker?" And Rabbi Bar Shmuel said to him, "Yes, I teach this baraisa. A hired worker, within his time for receiving wages, takes an oath and receives payment." How so? This applies in a case where the worker said to the employer, "You hired me, but you did not give me my wages." And the other, the employer, says, "I hired you," right? So he agrees that he hired him, but says the employer, "I gave you your wages." So in that conflict, and there's obviously no witnesses, and that's why there's a conflict that involves an oath, the employee can swear, "I was hired by you and I did not receive my wages," and now the employer is forced to pay. We don't have to bring further evidence. But this is only if he does so at the appropriate time. At the time of getting paid, he has this conflict, this debate, whatever, this argument with the employer. But if he waits, till the next day or days later, then he's going to have to bring evidence that he was not paid, or at least that he was hired, and he's not going to be able to swear the oath in this manner. Continues Rabbi Bar Shmuel, but if the hired worker said to him, "You fixed 2 coins as my payment," and the employer says, "I fixed only 1 coin as your payment." They're not arguing about whether he was paid or not. They're arguing over what the wage was that they agreed to. Then the burden of proof rests upon the claimant, who must provide witnesses to testify that the wage was the greater sum. Rav Sheshes suggested, since the latter clause addresses a case in which proof, meaning witness testimony, is required, the first clause must be addressing a case in which proof is not required. But this contradicts the statements of Rav and Shmuel above, that the worker may take an oath and receive payment only when he has witnesses that the person hired him. He can swear an oath that he hasn't been paid yet, but he's going to have to bring evidence that he was actually hired by the employer. Rav Nachman Bar Yitzchak says, and now we're on page 46a, both the first clause and the latter clause address cases in which proof is required, as even in the first clause, the worker must have witnesses testifying that he was actually hired. The Baraisa does not mention it because it teaches only with regard to proof that requires the employer to pay, but it does not teach with regard to proof that makes it possible for the worker to take an oath and receive payment. Right? When there's an oath sworn, that's in place of what would otherwise need to be proven by witness testimony. New subject. Rabbi Yirmiyah Bar Abba says, after Rav's death, the sages sent the following message to Shmuel from the study hall of Rav. Our teacher, instruct us with regard to the case where the craftsman says, craftsman is going to be as opposed to an employee. You have a contract with the craftsman to perform some work for you, provide some expert service, but he's not your employee, right? Yes, that's enough said. So our teacher instructs us with regard to the case where the craftsman says, you fixed 2 coins as my payment, and the employer, or in this case the guy who contracts with the craftsman, says, I fixed only 1 coin as your payment. Right? They're not arguing about whether they agreed that the craftsman was going to perform a service for him and be paid for it. They're arguing about how much he was going to be paid. In this case, this is different than an employee because it's the independent contractor, the craftsman. So in this case, who takes an oath? Then Shmuel told them, in that case, the employer, we're going to keep calling him the employer, but I think that's, the client, I think that would be a better word here. In that case, the client shall take an oath to support his claim, and the craftsman shall lose the difference. With regard to the fixing of wages, people certainly remember. The idea that it's an employer might have forgot, since he has a lot of employees, which employee he paid and which he didn't, and so the employee can swear an oath and be paid. But we have this, observation, at least the way business was handled in that time and place, that people don't, forget what wage or what contractual amount of payment they agreed to. That's more unusual. And so if there is a discrepancy in that, you're going to have to bring evidence for it. With regard to the fixing of wages, people certainly remember. So the sages instituted the oath taken by the worker, the employee, where he claims he has not been paid in a situation where it is reasonable to presume that the employer is distracted and apt to forget whether he paid one of his many employees or not, but he's not apt to forget what amount he contracted to pay, all the various employees. So the Gemara asks, is that so? But doesn't Rabbi Bar Shmuel teach in a Baraisa, if there is a dispute with regard to the sum fixed as wages, the burden of proof rests upon the claimant, i.e. the craftsman, here in the case with the client, and if he does not bring proof, his claim is dismissed. But the Gemara clarifies the difficulty. Why? So they're going to use the same word, but we have to just remember employer vis-a-vis a craftsman or employer vis-a-vis a employee, a hired worker. So, why? Have the employer take an oath, and only then shall the craftsman lose the difference in accordance with Shmuel's ruling. And Rav Nachman said Shmuel teaches the Baraisa disjunctively. Either the craftsman brings proof and receives the amount he claims, or the employer takes an oath and the craftsman loses the difference. Right? The craftsman could prove, what he's supposed to get paid. He'll get it. Since he can't prove it, we're going to leave it in the hands of the employer to swear an oath. And if he's willing to swear an oath that this is the amount that he is obligated to pay, then that's going to be the amount that he is obligated to pay. The craftsman should have got a witness or should have had a contract signed in the presence of witnesses. He doesn't, so he's going to lose out because he can't prove it. Why is the employer the one who is swearing the oath? Because he's got the money in his hand. The other one is looking to get paid. The Gemara raises an objection to Shmuel's ruling from a baraisa with regard to one who gives his cloak to a craftsman for mending. And then the craftsman says, you fix 2 dinars as my payment. And that when the owner says, I fixed only 1 dinar as your payment, then so long as it is so that the cloak is in the possession of the craftsman, it is incumbent upon the owner to bring proof that the fee was for 1 dinar. If the craftsman gave the cloak back to him, then there are 2 scenarios. If the claim is lodged in its proper time, i.e. on the day of the cloak's return, then the craftsman takes an oath and receives the 2 dinars. But if its proper time has passed, then the burden of proof rests upon the claimant, which is the craftsman trying to get paid the extra amount, and the craftsman would need to bring proof that the fee was 2 dinars and were past swearing an oath. The Gemara states the objection. In any event, this baraisa states that if the claim is lodged in its proper time, the craftsman takes an oath and receives payment, as opposed to the employer swears an oath and does not pay. So according to Shmuel's ruling, why should this be so? The employer should take an oath and the craftsman should lose the difference. Rav Nachman bar Yitzchak said in response, in accordance with whose opinion is this baraisa? It is in accordance with the opinion of Rabbi Yehuda, who says any time that the basic obligation to take an oath is directed at the employer, as in this case, as he admits to part of the claim, the sages instituted that the obligation to take the oath is transferred, and the hired worker takes an oath and receives his payment. But according to the opinion of the rabbis, the employer takes an oath and is exempted, as Shmuel ruled. So the Gemara asks, to which statement of Rabbi Yehuda is Rav Nachman bar Yitzchak referring? If we say he is referring to the opinion of Rabbi Yehuda in the Mishna on page 44b, how can that be? There he is being stringent and restricts the cases where the worker takes an oath and receives payment, more so than the rabbis who are lenient. As we learned in the Mishnah, Rabbi Yehuda says the worker does not take an oath and receive payment without any other proof unless there is partial admission on the part of the employer with regard to payment of the wages. Partial admission doesn't mean I admit I hired you, but I claim I've already paid you. It means I have already paid you some of that amount. Maybe I owe you more, but it's not that I have paid you nothing. Rather, he's referring to the opinion of Rabbi Yehuda in a baraisa, as it is taught a hired worker, as long as the time allotted for him to receive his wages has not passed, takes an oath and receives payment for his claim. And if not, i.e. if the time has passed, he's lodging the claim late, he does not take an oath and receive payment. He's going to have to bring proof, and if the absence of proof, he's not going to get paid. And Rabbi Yehuda said, when does the worker take such an oath? It is in a situation where he said to the employer, give me my wages of 50 silver dinars, which are still in your possession. And the employer says, you have already received a golden dinar, which is equal to 25 silver dinars from them. I've paid you half of what I owe you. I admit I owe you, and I've paid half of that. So I don't owe you 50 silver dinars. I only owe you 25. Partial admission. Alternatively, the worker said to him, you fixed 2 coins as my payment, and the employer says, I fixed only 1 coin as your payment. Either I've already paid you half, or we agreed to a different amount than what you're saying. Partial admission. The baraisa continues, but if the employer said to him, I never hired you, or he said to him, I hired you, but I already gave you your wages, then the burden of proof rests upon the claimant, i.e. the worker. And Rabbi Yehuda rules that it is only when they disagree about the amount of the wages owed to the worker that the worker takes an oath and is paid his claim by his employer. Rav Shesha, the son of Rav Edi, objects to this. But is this baraisa which says that the craftsman can take an oath about the sum fixed as the price the opinion of Rabbi Yehuda and not the opinion of the rabbis? Now, where Rabbi Yehuda is stringent and restricts the opportunities of the worker to take an oath and receive payment in the Mishnah. He has no evidence, but he can swear an oath and get paid. Again, this is in a society where swearing an oath is something that people do not do lightly. But who are we going to allow to take the oath and get paid, or take an oath and not pay? That's what we keep talking about in different situations. Now, where Rabbi Yehuda is stringent and restricts the opportunities of the worker to take an oath and receive payment in the Mishnah, the rabbis are lenient, granting the worker the right to take an oath as proof that he has not been paid. Then, in a case where Rabbi Yehuda is lenient in the dispute described in the Baraisa concerning the amount fixed as wages, right? They're arguing about how much was the agreement to pay, granting the worker the right to take an oath as proof of his claim. Would the rabbis be stringent with regard to the worker and grant the employer the right to take an oath and be exempt, right? If we're seeing that Rabbi Yehuda is, more lenient than the sages, and now he's gone even more lenient, are we going to say that now the sages are going to become stringent? So the Gemara wonders, rather, what can be said that the Baraisa is in accordance with the opinion of the rabbis? But if so, then with regard to the Baraisa, the Rabbi Bar Shmuel teaches that in a dispute about the sum fixed for the craftsman's wages, the burden of proof rests upon the claimant. Whose opinion is it? It is not the opinion of Rabbi Yehuda, and it is not the opinion of the rabbis. According to Rabbi Yehuda, the craftsman takes an oath to prove his claim without the wage. And according to the rabbis, it is the employer who must take an oath to exempt himself from paying the higher wage. So rather, Rava said that they disagree about this. Rabbi Yehuda holds that only in the case of an oath mandated by Torah law did the sages institute an ordinance for the benefit of the hired worker that he can take an oath to support his claim, apparently only if he lodges it in its time. When the employer's claim contains an admission to part of the claim of the worker, the employer is required by Torah law to take an oath to support his claim. But with regard to an oath mandated by rabbinic law, right, an oath by Torah law is what we were just talking about, now an oath by rabbinic law, such as where the employer denies owing any money, where according to Shmuel he still must take an oath, the original oath is already an ordinance, and we do not institute an ordinance to adjust an already instituted ordinance. By logic, we should have added this additional law, taking it a little bit further, but since that would be instituting an ordinance upon an ordinance, right? Rabbinic ordinances are passed by the rabbis, by the sages, in order to protect us from coming to violate Torah laws. They don't pass additional ordinances in order to protect us from coming to violate their own ordinances, lest it multiply ad infinitum. And the rabbis hold that with regard to an oath mandated by rabbinic law, we also institute an ordinance for the benefit of the hired worker. But with regard to a dispute about the amount fixed as wages, they maintain that the employer will remember the amount, and therefore he takes the oath and is exempt, as Shmuel ruled. According to Rabbi Yehuda, the worker takes the oath in that case as the employer admits to part of the claim, and the sages transferred the oath to the worker as the means by which he can prove his claim in the absence of real evidence like eyewitness testimony. Rav Shesha's objection is therefore not valid. The difference between Rabbi Yehuda and the rabbis is not that Rabbi Yehuda is more stringent. Rather, it relates to the circumstances under which they see fit to have the worker take the oath, right? And as we saw, when is the worker taking an oath? It's not always like what you would expect, right? There's going to be a difference where they agreed or they're disputing how much was the wage set for the worker, or where they're disputing whether the worker was paid or not, or whether they're disputed if the worker was even hired. This is going to produce different results, and it's not on some continuum of leniency and stringency. New subject. The Mishnah teaches, our Mishnah, number 1 here in chapter 7. How does the law of the worker taking an oath and receiving payment apply to one who was robbed? What's going on? What does a worker getting paid or not have to do with one who was robbed? The case is where witnesses testified about the defendant that he entered the claimant's house to seize collateral from him without the authority to do so. Right? Like, okay, so what's going on here? What does this have to do with with workers? So what we're saying is somebody thought that he had a valid claim to somebody else's property. Like, I'm holding collateral. I lent you money. You gave me collateral. You say that you paid me back the money. I say you haven't paid me back the money. You're sure you have paid me back the money, so you come into my house to take your collateral back. Since I'm saying you haven't paid me back the loan, you now taking the collateral back out of my house is robbing me. How does that intersect with employer and employee law? Let's keep reading. The cases where witnesses testified, so there is witnesses to some of this, witnesses testified about the defendant that he entered the claimant's house to seize collateral from him without the authority to do so. That's why he's now the defendant. The claimant said, you took items that belonged to me, and the defendant said, I didn't take them. Right? So we're not arguing over the original loan, whether you had the right to take the collateral or not. You're saying you didn't come into my house and take the collateral, but I'm bringing witnesses that you did. What's going on? The claimant takes an oath and receives payment of his claim. And the Gemara challenges, but he did not seize anything as collateral from him? The witnesses testify only to the fact that he entered the house for this purpose. So the witnesses didn't see you come and take the collateral out of my house. The witnesses just saw you enter my house. I say you took collateral, you say you didn't. The witnesses testify only to the fact that he entered the house for that purpose, but you don't know what happened inside. Doesn't Rav Nachman said, with regard to the one who takes an axe in his hand and says, I will go and chop down so-and-so's palm tree, and then the palm tree is found chopped down and tossed on the ground, we do not say that he chopped it down, but rather we search for evidence. In other words, circumstantial evidence. You said you were going to chop down my tree. The next day, my tree is chopped down. Probably you chopped down my tree, but maybe somebody heard you say that and took advantage of it to come down and chop my tree and take some wood or improve his view on the other side of my house or something like that, knowing that you would be blamed for it. No one saw you chop down my tree. That's why it's important that we have rules of evidence. Evidently, a person is prone to bluster without acting on his threat. Here also, it could be that he was blustering about seizing collateral, but he did not actually act on it. So the Gemara answers say that the case in the Mishna is where the witnesses testify that he entered the house and seized the collateral from him. They saw the whole thing. So, okay, that's proven that he came and took the collateral. So the Gemara asks, if so, let us ask the witnesses and see what items he seized as collateral from him, and there will be no need for an oath. And Rabbi Bar Chana said that Rabbi Yochanan said this is a case where one claims that the defendant took items that can be carried beneath his garments, and the witnesses could not see what they were, so there's still a discrepancy, possible discrepancy as to what happened, and therefore an oath would be necessary because we're still in the situation where somebody is claiming that he should have property that's in the possession of another, and he can't prove by eyewitness testimony, even though we're close, we're not there. So who's going to swear the oath is really the question. Rav Yehuda says, concerning a similar topic, if witnesses saw a person who entered another person's house, concealed items beneath his garments, and left, and then the person says, they were purchased, and that is why they are in my possession, not because I stole them, he is not deemed credible. Right? Let's review that again. If witnesses saw a person go into somebody else's house, pick up stuff in that person's house, put it under his garment, and walk out with it furtively, right? He's sneaking out. I mean, we say he's sneaking. Maybe that's an unfair characterization. But, Tom went into Jerry's house, took Jerry's stuff, put it under his shirt, and walked out. And witnesses saw that. Sounds like he stole stuff from Jerry, right? So if he says, no, he didn't steal it from Jerry, he bought it from Jerry, he is not deemed credible. But we said this only with regard to items taken from a homeowner who is not apt to sell his items. But with regard to a homeowner who is apt to sell his items, the one taking the items is deemed credible. In other words, if Jerry was having a garage sale and Tom went over and witnesses saw him put something under his shirt and walk away, it's not necessarily that he stole it from Jerry. Maybe he bought it from Jerry, but for whatever reason, the way he wanted to transport these goods home is under his shirt. And we're on page 46b now, and even with regard to a homeowner who is not apt to sell his items, we said that the one carrying the items is not deemed credible only with regard to items that are not typically concealed. But with regard to items that are typically concealed, he is deemed credible. Maybe what he bought at Jerry's house is a gun. Well, Jerry has a lot of guns. He sold one of his guns. And it's not normal for people to walk around holding a gun. It's much more normal to conceal it and carry it, especially in a, constitutional concealed carry state. That's the normal thing. So, of course he covered it up. That would be the normal way to walk away. So even though the witnesses say they saw him go over to Jerry's house, pick up a gun, and put it under his shirt and walk away with it, and he says, yeah, I bought it from Jerry, and then I put it under my jacket because that's the normal way to carry it, then he is credible. And even with regard to items that are not typically concealed, okay, so if he bought a cake and put that under his shirt, that would be weird, right? So we would think that looks more like theft. But even with regard to items that are not typically concealed, we said that he is not deemed credible only with regard to a person who is not generally secretive. But with regard to a person who is generally secretive, that is his manner, i.e., he would be likely to conceal items beneath his clothing, and he is deemed credible. Okay, forget cake, but cupcake. It'd be weird to put a cupcake under your clothing, but maybe he lives in a neighborhood where there's, ferocious pigeons who anytime you walk around with a cupcake, they go at your cupcake, so he put it under his shirt. That's why he did it. The point is that witnesses can see something and draw conclusions that may be erroneous if they don't know the context. And we said this only when the homeowner says the items are borrowed and the one who took them says they are purchased. But in a case where the homeowner claims that the items are stolen, it is not in his power to have his accusation accepted, as we do not presume that a person is a thief. We don't presume that someone is a thief. To say that someone stole, you have to prove that he stole. Furthermore, we said that the one who claims he purchased the items is not deemed credible only with regard to items that are typically lent or rented, where the homeowner's claim that they must now be returned is more reasonable. But for items that are not typically lent or rented, the person who took them is deemed credible, as Rav Huna bar Avin sent a ruling to the sages. With regard to items that are typically lent or rented, that someone took and said they were purchased, and that is why they are in my possession, he is not deemed credible. Right? That the kind of thing that people normally only lend or rent out, and this guy says he purchased it, that's unusual. And the guy says, hey, I never sold it. I thought I lent it to him. Or I didn't rent it, but he says I lent it to him, and now I want it back. And I never sell all my stuff. I just lend it out to my neighbors. I would never lend out, this lawnmower that has emotional value for me because it belonged to my dad, something like that. This is like that incident where Rava ruled to expropriate fabric scissors and a book of Agadah from orphans whose father had taken them, as they were items that are typically lent or rented. The oath of one who was robbed can be taken by others as well. Rava says even a watchman at the house can take the oath, and even the wife of the watchman can take the oath. Rav Papa asks, with regard to the employer's regular hired worker or his regular harvester, who are not appointed to safeguard the employer's property, what is the law? The Gemara responds, the question shall stand unresolved. We talked about this a little bit yesterday, the day before, where somebody has a caretaker at his house, and then he comes, and then without any reason, without any evidence to say that something is missing from the house, he just wants that guy to swear he's never stolen anything, right? And we said we could impose such an oath. Well, that's a caretaker. Well, what about if that's just the guy, the gardener, who comes and mows the lawn once a week? Does he have a right to impose on a gardener? Hey, swear to me that you've never stolen anything from the house while I wasn't here? Sounds like no. Sounds like we don't know. That question shall stand unresolved. Rav Yemar said to Rav Ashi, if one states a claim against another that he left his house with a silver cup and is liable to return it, what is the law? similar to the setup that Joseph arranged in Egypt when his brothers came with Benjamin, and he put the silver cup in the youngest one's bag as a test to see how the other brothers would react. Okay, so one states a claim, hey, you left my house with a silver cup and I want it back. What is the law? Rav Ashi replied, we see if the owner of the house is an affluent person, or if he is a trustworthy person with whom people deposit their valuables, as those are people who would typically have a silver cup. If the owner is in these categories, he takes an oath and receives payment of his claim. But if he is not, he does not receive the benefit of taking an oath in order to prove his claim. He's going to have to prove it. Right? So what we're saying, keep making the distinction between one who has to prove his claim and one who can simply swear his claim, and the court will extract property from another on the basis of that oath. The Mishnah teaches, how does this halacha apply to one who was injured? If witnesses testified about the injured person, that he entered into the domain of the defendant whole and healthy, but he left injured, so the injured party may take an oath and receive compensation. Rav Yehuda says that Shmuel says the sages taught that he needs to take an oath in order to receive compensation only if he was injured in a place where he is able to injure himself. But if he was injured in a place where he's unable to injure himself, he receives compensation without taking an oath. Where he is unable to injure himself. I guess they mean he receives compensation only if he can prove that he was injured, on the defendant's property or by the defendant's negligence, but not by an oath. And the Gemara challenges, and let us be concerned that perhaps he scraped against a wall and caused the injury himself. I'm saying injure himself in a way okay. What they're saying is unable to injure himself, meaning it must be that the defendant injured him. It wasn't in any situation where it could have been done to himself by mistake. The Gemara challenges, and let us be concerned that perhaps he scraped against a wall and caused the injury himself. And the Gemara explains, Rabbi Chia teaches that the Mishna is referring to a case where, for example, he has a bite on his back or on his elbows, which must have been caused by someone else. And the Gemara challenges, and perhaps a different person did it to him and not the defendant. And the Gemara explains, this is a case where there was no other person with him besides the defendant. There were only two people in a room. This guy walks out with a bite on his elbow. Must be that the other one bit him. He can swear an oath and get paid because there's no other explanation. Or maybe he doesn't even have to swear an oath because the evidence shows, because witnesses saw that there was no one else there. They didn't see the bite, but there was no one else there that could have caused the bite. So we're going to consider that to be sufficient and valid testimony that he went in uninjured, he came out with a bite on his elbow, and they know because of the witnesses that there was no other person in that room. Has to be that the other one bit him. You can't bite your elbow. Who knew? The Mishnah teaches, how does this halacha apply to one who's a opposing litigant is suspect with regard to the taking of an oath and therefore is not permitted to take the oath? One is suspected if he had found to have taken a false oath in the past, whether it was an oath of testimony or an oath on a deposit, which are prescribed by Torah law, or even an oath taken in vain. And the Gemara asks, for what reason does the Mishnah emphasize even an oath taken in vain? If you took an oath falsely, then you become a person who is suspect of taking false oaths. So we're not going to give you compensation based on your own oath. The Gemara explains, the Mishnah is speaking, utilizing the style of it is not necessary, meaning it is not necessary to state that one who is suspected of falsifying these oaths is disqualified from taking oaths, as they entail the denial of a monetary claim, i.e. due to the false oath, someone incurs financial loss. But it is necessary to state that even that oath, the oath taken in vain, which involves merely the repudiation of one's verbal commitment, nevertheless grants one the status of a person who is not credible and who is disqualified from taking oaths even in a monetary situation. I'm almost done. Questions or comments, please get them in now. The Gemara suggests, and let the Tana also teach that falsifying an oath on an utterance, which is also an oath without monetary consequences, disqualifies one from taking oaths. And the Gemara responds, when the Tana teaches which types of false oaths disqualify a person, it includes only oaths with regard to which, when one takes the oath, he is at that time falsely taking the oath. But with regard to an oath on an utterance, such as the oath that he will eat a specific fruit that day, where it can be said that he took the oath with true intention and intended to eat that fruit, but ultimately he failed to do so, the Tana does not teach, as one who does not fulfill such an oath retains his credibility to take oaths, since he did not consciously lie. Right? One who swears, I will not, one who says he will not eat an apple tomorrow, and then he ends up eating the apple. We don't call that somebody who is suspect of swearing false oaths, because he really intended to keep that oath. He's not a liar. Something came up and he ended up eating the apple. That would be distinguished from one who swears that he didn't eat an apple the day before when in fact he had. The Gemara raises a difficulty. It works out well to make this distinction for one who is liable on an oath on an utterance like, I will eat or I will not eat, where it is possible that he was not lying when he took the oath. But with regard to oaths about the past, like I ate or I did not eat, then what can be said? Since he certainly did take a false oath, therefore, maybe we should not allow him to take an oath in a monetary situation where he could receive compensation just by swearing an oath, like an oath of a partial admission to a deposit. Maybe we should transfer the one who takes the oath in that litigation to one who is not suspect of false oaths, because this guy once swore falsely in an oath of utterance about a past event. And the Gemara answers, teach the Mishna, i.e. understand it to mean an oath taken in vain, and any oath that is similar to it, i.e. that is clearly a falsehood, disqualifies one from further oath taking, like somebody who took a false oath on an utterance about a past event. And that's as far as we're going to go today. We're at the top of 47a. I'm going to take one question. But reminder, tomorrow, Sunday, we're going to have class at noon Pacific, not a regular time, 6 p.m. Our dear friend Marcus Freed is premiering his one-man show about his journey after having a traumatic brain injury. This show is premiering here in LA, and then it's going to go, I think, to the Edinburgh Play Festival, and it's going to travel around the world. Marcus is a brilliant actor and writer, and here it's such a personal story that I'm very familiar with because we visited him in the hospital. We're actually mentioned in this play about having the traumatic brain injury and his recovery from it, and we want to lend our support to him. So catch that play when it comes. What is the title, Nina? What is the title? I think it's Is Marcus Alive? I think the title of the play is Marcus Alive? But we're seeing it tomorrow for the first time. And that conflicts with the regular Sunday time for us. So tomorrow, Sunday, noon Pacific, is what time we're going to do tomorrow's class. Joseph's question, this all makes me wonder what kind of payment systems they had at this time. Did they have hired servants to... Marcus is alive. That's the title of the show. Marcus is alive. Baruch Hashem. Marcus is alive. Watch for it when it comes to your city. This all makes me wonder what kind of payment systems they had at this time. Did they have hired servants to deliver payment on behalf of the employers? That's a very interesting question. I don't know. I don't know the answer to that. But I think something we see over and over again as we read about these kinds of employment, disputes, contracts, even like banking. We've talked about banking. We think of the ancient world and that they had these, they rode around on donkeys and had wagons with thick wooden wheels, and it's just such an agrarian society. And we tell ourselves, wow, we're so sophisticated, and they weren't. Yeah, they had such sophisticated systems. Maybe they didn't have electricity and telephone and internet, but they had incredibly sophisticated systems for doing everything that they needed to do. Including, financing larger ventures so that large ventures could happen. We're talking about, those areas where there was a conflict, there was a dispute, and they needed to settle it because they, the parties didn't have a clear contract at the outset. But those are the rare cases where the law needed to step in and decide how to deal with it. That's obviously, like how many business deals in our world result in litigation? A tiny fraction of all the business deals. It was the same back then. A tiny fraction ended up being litigated. The majority worked, right? They worked, and they had that absolutely sophisticated systems for payment, for getting money. And that it's really sophisticated when you think that somebody's going to travel and be weeks or months away, and there's no ATM, and there's no telephone, telegraph, nothing for quick communication, and yet they're able to, draw amounts in one location and be paid in another. It's fascinating. I wish I knew more about ancient banking systems, but I do know that they were pretty sophisticated, as gets touched on in our journey through the Gemara. That's what I've got for us tonight. With God's help, see you tomorrow, Sunday. Different time than normal, noon Pacific. All the best.